Malicious mischief in the third degree, second degree, or even first degree. What is it besides something really hard to say? Well, malicious mischief in Seattle or in Washington state is a crime that involves the purposeful destruction of property. The statute reads something like knowingly and maliciously causing physical damage to the property of another. And it's a very common charge in Washington state and one that isn't well understood. My name is attorney Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. We're a criminal defense firm located in Lynnwood, Washington, and we've been defending people charged with malicious mischief and other crimes for more than 20 years. And I wanted to put together this video to explain what malicious mischief is, the different types, including felony and non-felony, and different types, including regular malicious mischief or domestic violence malicious mischief. The most common charge we're going to see for malicious mischief is probably malicious mischief third degree domestic violence. And malicious mischief third degree means the value of the property damaged is less than $750. If it's more than $750, it goes to second degree, which is a felony, or it can go higher to the first degree, which is even a more serious felony. And why that's the most common charge, malicious mischief third degree domestic violence, is the domestic violence tag means that the relationship between the defendant who supposedly broke the property and the property owner is a family or household member. And what that means is basically your wife, your boyfriend, your girlfriend, your roommate, your brother or sister. Those people have a family or household relationship as defined by statute. So if you end up in an argument, and the most common thing is, I'm looking at my partner's phone and I don't like what I see, so I slam it down and break it. Someone calls the police come out and see the broken phone. Now, whoever broke the phone gets arrested for malicious mischief, typically third degree domestic violence. And that's a gross misdemeanor offense, typically carries a maximum penalty of a year in jail and a $5,000 fine, and it's pretty serious. So what do we do about it if we run into a malicious mischief charge? Well, the first thing we do is we pay attention. If it's a domestic violence charge, we have to handle it one way. If it's not a domestic violence charge, let's say you knocked out the window of your neighbor's car because you were mad. And you don't have a family or household relationship to your neighbor, unless you dated your neighbor, then that's a non-domestic violence case, and that's handled a whole separate way. So on malicious mischief third degree domestic violence, we can't do something called compromise of a misdemeanor. We can't just pay for the property and ask the court to dismiss the case. On a non-domestic violence case, we can try to do something called compromise of a misdemeanor, where we can pay for the property and ask the property owner to sign something, basically telling the court it's okay to let us go. And I have a separate video about compromise of misdemeanor, so take a look for that if that might apply to you. But on a domestic violence charge where the property is owned by your husband or wife, your boyfriend or girlfriend, etc., then we have to defend in more traditional ways. We might want to try to take care of the costs of the property, but it doesn't guarantee that we're going to be able to make the charge go away. So for our clients, we might have our clients do some type of anger management class, do some type of education so we can deal with the situation better next time. We might have our client do some counseling to help improve on whatever the underlying argument was about. Those are two things we might do. We might also just defend the case outright. Maybe the property only got broken in some type of defense. You were trying to defend yourself and the property was broken as an accident. The watch got ripped off someone's hand and the band broke. So that type of thing is one way we can defend. A confusing thing for people charged with malicious mischief is sometimes they think if you're married, well, I just broke my own property. I'm allowed to break my own property, right? So the typical fact pattern there would be a husband and wife arguing, and maybe the wife gets really mad and smashes the dinner plate. The police get called, the police see the smashed dinner plate, and even though the husband doesn't want anything to happen to his wife for a smashed dinner plate, they arrest her and take her away. And you think, well, why can't I damage my own plate? Well, if you're married, the presumption in Washington state is everything is community property, which means it's half the wife's plate and half the husband's plate. So when you're breaking that plate, you're breaking property of another, the half that the husband owns. And so what do we do to defend that case? Well, what if that plate was obtained prior to marriage and is the separate property of the wife? Well, that's not property of another then. And so that could be something we argue, because oftentimes police are forced to make assumptions to try to deal with the situation. They're just going to assume, in this case, plate for the example, was obtained during the marriage. But if it wasn't, and we can show it was obtained prior to the marriage by the wife only, then we could have an absolute defense to the charge. So malicious mischief, serious case, hard to say. What you need to do if you're charged with this is get an attorney. Do not try to handle it yourself. There's a lot of great attorneys out there. If you want to talk to us, again, my name is Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. Just give us a call. We'll try to set you an appointment. We'll talk to you about what happened. We'll make sure you understand what's going on, and we'll do everything we can to be there for you. Thank you.